presentation, which is entitled The Essential Importance of Communication Skills in the Modern Legal World, No Moot Point. Sorry, let me just make sure the screen. Thanks. In fact, what I have to say has been influenced to some degree by some of the things that have already been said this morning, because there's been talk of the need for much more practical emphasis in legal education and the introduction of psychology, and that sits very comfortably with the comments I have to make about the essential importance of communication skills in the modern legal world and as a fundamental part of legal education. I believe that the time has come to make communication skills a mandatory feature of legal education, and I'm going to explain why. In fact, especially since I've had the privilege of getting to know people at CUHK and learning more about legal education, I question more and more the need for a much more practical emphasis in legal education. And my comments as regard to the need for communication skills to be implemented as a fundamental aspect are based predominantly upon my experience as a practitioner since the early 1980s. Obviously, I put in my abstract. I'm not going to spend time sort of introducing myself, but I've been practicing at the criminal bar. I'm joint head of 25 Bedford Row, which is a large criminal set, and also sit as a part-time judge. So I've been heavily involved in the practical side of the profession and also in what might be called the sort of business side of the legal world, although that is definitely not my forte. And my comments today are going to be focused really on communication skills and the spoken word, but undoubtedly communication skills span written communication as well as verbal communication. And what I'm going to do is to consider the question of what communication skills are and why, as I see it, they've become so important in terms of legal training. But the reality is that in the course of my career, I've come across so many incredibly bright lawyers, far brighter than I am or will ever be, and also pupils and students in the academic world, and many of them are excellent communicators. But sadly, many of them are not. And there is a real issue as to whether some of the most brilliant products of legal education are equipped to communicate what it is they know and the fantastic skills they have. And we see it at 25 Bedford Row when we interview, where very often the quality of the CV, which is outstanding and compelling, isn't matched by the ability of the applicant to communicate those fantastic qualifications and assets. Now, as I see it, the need for communication skills to become part of legal education has increased and enhanced significantly over the decades. Why is this? Well, there are a number of reasons. Widespread expansion in fields of law, greater demands of clients, born of wider access to education and resources, clients, and obviously my emphasis is on criminal clients, so much more so perhaps in other spheres of law, but clients are far more better educated and in a position to express themselves and their concerns and their demands. The global world, obviously email, thus triggering the need for precision, conciseness, clarity in the use of language where lawyers are concerned, instant demands of responding to important legal issues by email under pressure of time. We all have to deal with these issues quickly and effectively, and without training in communication skills, without being alerted to the things that are important in deciding what the substance of our communications are, it's dangerous in my view. And of course, the digital world and increased access to digital justice, conferences and meetings, mass availability of Zoom, Skype Business, Microsoft Ready, modes of communication galore for lawyers have made it all important that you have training in the art of communication and do not simply stumble through legal life learning as you go along, because obviously that can cost a lot of time, a lot of money, and liberty as well. So it's in my view, a very important consideration indeed. Now, of course, I appreciate that not all law students aspire to be lawyers, but as I see it, that doesn't really matter, because communication is a vital component of any occupation based upon legal grounding, but most particularly, of course, where legal practice is concerned. And so what I propose is that no law graduate complete his or her training without freestanding education in legal-orientated communication skills, whether it be via education in those skills direct, via compulsory mooting, mandatory training in advocacy, trial practice, or any combination. I mean, as a practitioner, I don't deign to be qualified to speak on how these skills should be incorporated into legal education. I'm just advocating that they should be, and I'll come in the final part of what I have to say shortly to the ways of educating in communication skills that I feel might be most productive. What sort of communication skills am I referring to? Well, Google defines communication as, quote, imparting or exchanging of information by speaking, writing, or using some other medium. And the Oxford Dictionary defines communication as, quote, imparting or exchanging of information by speaking, writing, or using some other medium. So that's the umbrella under which I'm making my comments. And the sort of skills that lawyers or students who are being educated in a legal forum need to have identified, nurtured, developed in the way they present themselves are correctness, clarity, consideration, creativity, courtesy, the ability to judge other people in the way that communications are unfolding, risks of alienating clients, other lawyers, judges, jurors, tribunals, the need to pay attention whilst communicating, deterrence against using over-technical language, the risks of reaching hasty solutions or giving unwanted advice. Email springs to mind again. How communication is affected by technology, new terms and words, how it's influenced, importantly, by culture, race, and all of those considerations. And of course, in learning about communication, lawyers in particular have to be trained in something that is fundamental, and many of us are not particularly good at, which is listening skills. Listening skills are important, and as important as any other form of communication skills. And within the framework of listening skills, reluctance to interrupt, sensitivity to what your client is telling you, or what other lawyers are arguing, or what judges are asking you, or juries may feel, not being obsessed with controlling the conversation or argument, and the basic need to listen, to absorb, process, consider, and deal with the information that's conveyed to you. All of these skills and qualities are part and parcel of the requirements of day-to-day life as a lawyer, and I would suggest almost anything anybody does, having had legal training, whether it be in an office, a courtroom, prison environment, a coffee shop, or whatever. And I entirely endorse what Mr. Rowett, our first speaker, said. Although I'm not suggesting that necessarily anything else is sacrificed, that the emphasis on these practical matters and communication in particular is something that needs to be looked at in the modern world. Very briefly, because having moderated and insisted everybody else keep to their time, just going to move on and say that a fundamental part of training in communication skills within the framework of legal education would have to be persuasiveness. We have to be taught how to be persuasive. It doesn't necessarily come naturally. And so for law students to be taught the art, skill of persuasiveness is absolutely vital, because persuasion is an essential ingredient of what you need to do when negotiating, when arguing, when advocating, when submitting, when advising, perhaps when trying to persuade people to join your firm or your chambers, dealing with your opponents, to take a particular course of action. And it's a pity that young lawyers have to learn how to persuade when they're released into the big wide world, and that there's no training in it. Now, moving on to the question of how all of this is to be achieved, and dealing very simply with what I advocate. Obviously, mooting is an important feature of legal education, but it's not mandatory, and it should be mandatory for all students. And I've been lucky enough to participate in mooting at CUHK with Professor Michael Ramsden, and I've seen how enthusiastic some students are and how they benefit from it. But it should be made compulsory. And the reason why it should be made compulsory is because it gives the practical implication and knowledge to students of law in a way that they will never find in books, and they would be unaware of if they didn't participate in mooting. And it enhances practical and theoretical knowledge in a way that academic education can't. It enhances writing and organizational skills. It improves skills in research analysis. It develops the ability to work closely with teammates, sharing mutual goals. It increases in confidence in public speaking. It helps to develop an understanding and expounding of the law, and improvement in ability to think on the feet. And it unquestionably enhances, develops, nurtures communication skills. And unless students participate in mooting, they cannot conclude their legal studies, in my view, in a manner which properly equips them to go out into the big wide world. Overriding everything else I've said is confidence, that students, people don't know what their abilities are until they are pressed into testing them, and that compulsory mooting, training communication skills, will take students out of their comfort zone. And that in itself is an excellent thing. And another variation on the same theme is training in the art of advocacy, which is different to mooting skills. And again, I've been fortunate with Professor Luke Marsh to be involved in this at CUHK. And I know that an excellent trial advocacy course is run, but again, it's optional. And it's for students who have the confidence, and it's the same in the UK, who have the confidence to feel that they can engage in advocacy. But those who are not required to do so will never know whether it's something that they could be good at, and they won't have the opportunity to develop the requisite skills. Advocacy is a skill and not a science, and it needs to be taught. The elements of persuasion have to be learned for young lawyers, learning how to present interestingly to engage the audience, a sense of audience, learning how to plan and structure what you have to say, learning how to draw from your own personality, to have confidence in your own personality, how to maximize the use of your own voice, what words to choose, and how to put your presentation together, or even how to present yourself in interview. Because if you've had no training in communication skills, you may find you don't get beyond the interview stage. And of course, for lawyers themselves, learning how to present submissions, arguments, whether it be in writing, but more predominantly orally. And the art of advocacy is something which is as important to training in legal law, to training of lawyers and legal education as any possible skill whatsoever. It spans every feature of every aspect of a lawyer's life, and yet it's not traditionally a mandatory subject, whether in combination with mooting, instead of mooting, or whatever. And the final individual factor is trial practice, which I don't have time to dwell upon today, but clearly for law students to have real insight to what it's like conducting a trial, the knowledge, the instincts that you need, the discipline you need, is something that will be, in my view, invaluable and should be indispensable. So in concluding, on the topic that I've chosen to speak about, which is the essential importance of communication skills in the modern legal world, I would suggest that the time has come, alongside a more widespread practical emphasis, for communication skills to become part of legal education. And I would maintain that without effective training in communication skills, the brilliance of young lawyers is something which in many cases will never be carried through in the way that it could be if they were able to communicate their knowledge, their abilities, and everything that is within them. So I suggest that the essential importance of communication skills in the modern legal world as regards legal training is no moot point. And that is what I have to say this morning. So I think I've just exceeded my time by a couple of minutes. And there are some questions, the first of which, what I'll do is I'll pose the question and then answer it myself if I can. Even from Simon Bruman, even taking account of the transferability of these skills, is there a problem with designing legal education around these skills when only around 1,200, 35,000 UK students go to the bar? Is it the price worth paying? Well, Simon, that's a very good question, and it goes to the heart of really what I'm saying. I think it is a price worth paying. My observations are not directed at students who go to the bar or who even contemplate going to the bar. As I've said, I recognize that not all students who undertake legal education want to be lawyers, but most of them, as I believe, do. And I'm suggesting that the sort of communication skills which I've been discussing are applicable across the board, that the boost in confidence, that the appreciation and realization that an individual does have those skills, is able to express themselves in the clearest possible way in any context which has to do with or derives from their legal education, is a price worth paying, and that communication skills are of paramount application across the board where law students are concerned. The next question comes from Professor Luke Marsh, which is this: bearing in mind you mentioned the growth of virtual court hearings, which may be an ongoing feature for junior lawyers in the post-COVID-19 world, how have your own experiences during the online court hearings shaped the way you communicate, if at all? Well, obviously that's a very pertinent issue at this time, and in a nutshell, almost all court hearings in the UK over the last 3 months have been virtual, not trials, but everything else, including bail applications, sentencing hearings, administrative hearings. And in relation to the first two, bail applications and sentencing hearings, obviously we're dealing with incredibly important issues. For example, I did a virtual hearing recently for a pregnant woman, a bail application, who was in isolation in a prison in the UK for drugs offences. So, although virtual, the forum is incredibly important. And in response to Luke's question, what I would say is this, that I feel that the need for lawyers to have maximum communication skills is enhanced by the current and possibly future prevalence of virtual hearings. The need to be aware of what's going on around you, the need to make sure that you get your point across, the need to be sensitive to your tribunal actually listening to you and to be aware of whether you're actually communicating what you have to say. These are all things that become even more important in a virtual context, because you've got that distance between you. And one of the things that motivated me to choose this topic for today, and which is why Luke's question is intuitive, is because of virtual hearings. Many junior members of my chambers have been involved in them, and the possible increase in the number in the future. So thanks for that question, Luke. And then a question from Professor Steve Gallagher, who's asking, do I think these skills can be taught in large groups? The answer to that question, Steve, is yes, I think they can be taught in large groups. Obviously, and this is your field of expertise, the logistics of all this is not something I'm capable of or qualified to comment on. But in general, I would say that the kind of things that I've been discussing can and should be taught in large groups, so that there can be interaction and discussion. The subject matter is easily capable of being transmitted within the framework of a lecture type context. And then if it's possible or feasible, obviously, for the practical aspect, as it is in the trial advocacy course at CUHK, to be set aside and dealt with in combination, then that's the best possible thing. And obviously access to courts and much more closer links with practitioners too. But the simple answer question is yes. And then question, which obviously I have to include, is from the Dean of CUHK. Lutz, thank you for your question, which is this. There's only so much that students can study. Which substantive law topics should be dropped to allow for communication skills to be taught? Well, that is a blockbuster question. I'd be proud of that question if I was cross-examining a witness, because it's a pretty hard-hitting question. And I can't, at this moment in time, I don't feel that I ought to select one particular subject. And I'm mindful, as I said at the start, of the logistical challenge of all this. What I would say in principle is that the type of subjects that should be dropped, if any subject at all has to be dropped, are those subjects which don't have any potential for application in the big wide world. So, and I'm not suggesting for a moment that I believe that those subjects are useless or are not important, but I do believe that legal education needs to assume a more practical emphasis. And if anything has to be sacrificed for the sake of emphasis upon training and communication skills, then it ought to be any aspect of legal education that is theoretical, that is largely academic, and that won't be of direct application in the world of legal practice. And I hope that's a sufficient answer to the question. Just time, I think, for one more question, and then my time is up. Question from Sarah Mililori. I'm sorry if I can't pronounce the name correctly, which is slightly embarrassing because my topic is on communication. As you said, self-confidence is really the starting point on which to build upon communication skills. I'm afraid universities will not have the resources to offer some kind of coaching to students to develop the confidence. Do you think there are alternatives that could work? Can simple exposure to public speaking build self-confidence? Well, Sarah, I think the answer to that question is yes. I think that simple exposure to public speaking can build self-confidence. Whether that means much more access to the courts, to the legal world, but I think it can. But fundamentally, I think that what's required is a clear understanding by students of what communication actually involves, and the skills and personality features they need to be alerted to in order to nurture those skills, and then as much interaction between students as possible. And then I just feel that students who are shy, nervous, don't have confidence, may be staggered by their potential if and when their communication skills are tested. But in conclusion, I would say that I fully acknowledge that resources are limited, that time is limited, that that there isn't a promised land where everything can be taught within the framework of legal education that one would like. But I do strongly believe that if we're looking to produce the finest quality of lawyers in the next generation, that communication skills is a feature of legal education which needs to be incorporated as a must rather than a might. So that brings me to the end of my presentation. In fact, it brings me to the end of this session.